What happens if the dealership can't fix your car under warranty? If the dealership is unable to fix your car under warranty, you may have a valid claim under California's Lemon Law. The Lemon Law provides a remedy for buyers of new or certified pre-owned vehicles that have a substantial defect that affects their use, value, or safety and cannot be repaired after a reasonable number of attempts. If your vehicle qualifies as a lemon under California Lemon Law, the manufacturer is required to either replace the vehicle with a comparable one or provide a refund buyback of your purchase price, including any incidental costs such as towing and rental expenses. If the dealership is unable to fix your car under warranty and the manufacturer refuses to resolve the issue, you may need to take legal action to enforce your rights as a consumer. This will involve hiring a qualified Lemon Law attorney who can file a lawsuit on your behalf, communicate with the manufacturer, and negotiate a resolution to your case. Overall, if the dealership is unable to fix your car under warranty, it's important to act quickly and assert your rights under the Lemon Law. Our experienced attorneys can help you navigate the process and achieve the best possible outcome for your case.